Earlier this week, Peter Seidler, the widow of the Padres' former owner, Peter Seidler, filed a lawsuit attempting to take back control of the ball club from Peter's brothers, Matthew and Robert, which raises the importance of living trusts and wills. Joining me now is talk about it as a person who knows all about it, Justin Isaac from the Lawyers and Blue Jeans Group. Justin, welcome back to KUSI.
Thank you.
All right, I find it hard to believe a man like Peter Seidler, who had a cadre of Ivy League attorneys around him and financial planners and whatever, he knew that for at least 6 months that he was going to be passing away, probably longer. I find it very difficult to believe that that man did not have an ironclad document as far as the succession plan of the Padres.
You know, looking at the documents, because I was reading through the whole thing yesterday, it's almost 100 pages, and I agree with you. He does have a pretty ironclad estate plan. There's multiple amendments, too. And when you get into a situation where you have an estate plan that hasn't been updated for years, maybe there's some mystery as to what they meant or what their recent wishes were. But he updated it, I think it was 2021. It was a complete revamp of his trust, and then an amendment, and then another amendment. And he never mentioned that she was to be considered in the succession. In the lawsuit, she put up she offered as evidence a handwritten document that she was to be the first choice for succession in control person with regards to the Major League Baseball. However, that was in 2020, and he had 3 updates, or at least 2 updates to his trust since then, which would negate that handwritten document, because that means that, well, why didn't he change his trust? If he did intend for her to be the first choice, as it's purported...
So then this is a slam dunk then. I mean, I guess when the appeal to the fan base, again, I met her for the first time, very nice person, and you're very sympathetic losing to your soulmate, so I don't mean to trot on that. But, I mean, the appeal to the fan base almost seems like a Hail Mary, like, hey, don't forget about this legal document here. I'm the better, my soulmate wanted me to run the table.
Well, I think that what some people will do is emotion comes into this, right? And emotion is inevitable. However, as a lawyer, unfortunately, and this is where we get a bad reputation sometimes, we have to look at the facts and put emotion aside. And when reading through the lawsuit, I did see a lot of emotion, a lot of, you know, they were soulmates, and they ran the club together, and the other side is going to move the team to a different city, which really does play on San Diego's heart.
Because we're especially after losing the Chargers.
Yeah, and I understand that as well, too, but there are some pretty serious allegations in there about breach of fiduciary duty, which essentially means you cannot do something that is self-serving and doesn't benefit the trust.
If any of those allegations are true, does that in any way break the trust or break the succession plan?
Not necessarily. They can be penalized as the trustees. They can be removed as the trustees of the trust. But again, there's a whole order of succession of trustees, and she's not mentioned on there. Now, I did see some articles that said that she was expressly prevented from being the trustee. Not the case. There's nothing in there that says that she's prohibited from acting as a trustee. I didn't find that in the document anywhere, but she was more omitted, which is a big difference. So ultimately, she could, if the whole succession, trustee succession fails. However, there's a lot of people in there, and they didn't breach any duties.
All right, so how does this play out? Because one element we're not talking about is Major League Baseball, who hates these kind of stories. And they want stable franchises, and even though there's a document in place, this rocks the boat a little bit. So there's that element. How does this... Who's going to decide the fate of the Padres?
I don't think that we're going to get to a point where there's a fire sale or anything like that. It seems like more this might be where people are just removed from power, right? The people the nefarious actors, if that were the actual case, they'll be...
Who will make that a judge?
Yeah, judge or jury.
So this will go before a judge at some point. What's the timeline on something like this?
Oh, this is Texas, too, so it's going to be a lot quicker than what we would do. So I would imagine a year or so. But the one thing I found very interesting is that the whole document was available for us to see. That would never happen in California. I was so confused as to why I could read a private trust in a court document, whereas in California, it's under seal. You would never be able to see it, and that's why you never hear about these things or get to read them. But it's Texas, so I'd say probably a year.
So is there an advantage for her filing in Texas for just that reason? Or
For the speed, possibly. I don't know if it would necessarily favor her as much. I asked my friend who's a Texas probate attorney too, and she said it doesn't necessarily favor her filing in Texas, but she's domiciled in Texas. She lives there. That's where the trust was created, apparently, too. So Texas is the favorable jurisdiction for this.
All right. So as we wrap this up, because I think Padre fans are kind of on pins and needles. They want to see the team spending money like they did under Peter.
Yeah.
And this feels like this is slowing that down. Whether it is or not, we don't know. But just for people at home who don't have billions of dollars or millions of dollars, the importance of having a plan, if you have kids, could you speak to that a little bit?
Absolutely.
Here, I'll let you drum up a little business.
I appreciate it. Well, I think that having a plan in place, making sure that you're not going through the courts, your family doesn't go through the courts, having a trust in place is the most important thing, but also succession planning for a business as well. And that's what this really comes down to, is there was no, there was, but she's challenging it in court. But doing this instead of going through a probate where the judge is ultimately going to decide, I think that's it kind of sells itself right there, because we don't want to end up in court. This is more of a conflict ending up in court too. So it's one of those things where it might have been inevitable because they just don't agree. So make sure your wishes are clearly stated, and that way there can be no ambiguity.
Nobody wants to spend the money. No one wants to talk about death. No one wants to talk about death with their kids. But you have to do all three.
Absolutely. And when it comes to probate in California, our typical probates are going to be a minimum of 2 years. So if you pass away, your estate gets stuck in the courts for 2 years on average, and there can be any kind of fighting and all public knowledge of your assets and whatnot. So it is not a good process. I know Texas is a lot quicker, but that's what happens in California.
Thank you so much for your time. We appreciate your insight, and I'm sure this conversation will probably continue as the weeks go by.
I'm sure it will.